Hi everyone, welcome to another eMoney Experience podcast. Today we will be talking about APP scams and the Payment Systems Regulator reimbursement requirement contained in SD 20, Specific Direction 20. This has been a long road and many of you will already be very knowledgeable on the PSR's reimbursement requirement. It's been the subject of considerable lobbying in the industry, and various Treasury, financial services subcommittees at government level, at the Treasury, discussing issues, challenging the PSR, challenging Chris Hemsley on his erstwhile managing director of the PSR and his policy decisions. But now we're at the end of the road and the PSR direction is actually on foot. So as at October 7th, so 1 month ago. And PSPs are meant to be underway reimbursing customers for scams, for paying reimbursement claims for scams, authorized push payment scams that they've been scammed out of since the 7th of October this year. But there's still a bit of uncertainty in terms of scope, which PSPs are in scope, what is a relevant account, what PSPs have to reimburse, what payment services are in scope. It's kind of different to what we originally thought reading the draft specific directions and reading the PSR's policy statements. So I thought we'd discuss it a bit more today. Let's just get into it, Okay, so APP scams, PSR, specific direction 20, scope creep. So first, this is the actual reimbursement requirement, faster payment systems reimbursement requirement. When a victim reports a reimbursable faster payment system APP scam payment to their sending PSP, the sending PSP must reimburse the victim in full. This is the FPS reimbursement requirement. Everyone already knows this. This is really the issue. So that's actually the reimbursement requirement. That's the direction that requires us to reimburse victims. So it's not contained in the payment services regulations or eMoney regulations. It's a payment systems regulator direction. There has been some talk in industry recently of bringing judicial review against the PSR, or perhaps not bringing judicial review against them, but doing something to get the PSR to change their policies. The reimbursement policy, it's been a long road, as I said before, and it's not popular, generally speaking. PSPs are not fully on board with all of the PSR's decisions, all of their policy decisions. Some PSPs consider that it kind of goes beyond what's fair. Why should PSPs be liable for fraud and crime committed by a third party? So the industry is not wholly sold on the PSR's policy decisions, and there has been talk of doing something to force the PSR to change their policy decisions. So, for example, originally the PSR said that PSPs were going to be required to reimburse customers up to £415,000 per claim for each claim, and this was aligned to the FOS liability cap. So you can't recover more than £415,000 at the FOS. It's now 430, but it was 415 at the time. And so this was not received well by industry, and then industry lobbied very significantly and successfully to get the PSR to change that decision, change that policy decision in relation to this enormous extent of liability, £415,000, And now, thanks to tremendous lobbying by industry and industry associations, trade associations, the PSR pivoted at the last moment and reduced the extent of liability to £85,000. It's still enormous, but we'll take what we can get. So that's kind of an example of doing something to get the PSR to change their minds, to change their policy decision. So to change the extent of liability, the industry lobbied fiercely lobbied, letters to politicians, to the Prime Minister, to the Economic Secretary, to the Treasury, fiercely lobbying. But in order to get the PSR to change their policies and their specific directions any further, there has been talk of threatening the PSR with judicial review, which means taking them to court and presenting an argument that they have perhaps acted outside their powers, or they've done something wrong in terms of handing down their policy decision in relation to reimbursement, the reimbursement policy, and then the court would rule that they acted outside their powers, and then the PSR would have to change their policy decision. There has been talk of this happening, so I thought we'd discuss it just briefly. So you bring judicial review against the government. So judicial review is bringing a claim against the government and saying you've done something unconstitutional and asking the court to require the government to change what they've done. So repeal an act or change a policy. So there are 4 grounds to bringing judicial review. So illegality, irrationality, procedural fairness, and legitimate expectations. So illegality, here we'd be claiming that the PSR acted outside their statutory powers by using Section 54 of FSBRA to direct EMIs, saying that they don't have the power to direct EMIs under Section 54 of FSBRA. That's one school of thought. The industry could bring judicial review on the basis of irrationality by arguing that the PSR's policy decisions are so unreasonable such that no reasonable authority could have come to it. So the reimbursement policy doesn't pass, I think it's called Wensbury, unreasonableness. Procedural fairness. So the PSR, whilst their policies are substantively fine, we could argue that they failed to follow a required process. So they're required to consult, for example. So if they didn't follow procedural fairness, they didn't follow some kind of process that they're required to by statute before handing down a policy. For example, if they just published a specific direction without any consultation or without publishing any drafts and it was effective immediately, there would likely be some procedural issues with that conduct. But they didn't do that in this case. There was there were many consultations, and it was a very long road, as we've discussed. And then legitimate expectation. For example, the PSR have said something, and then some stakeholders have relied on that statement by the PSR. They had a legitimate expectation that the PSR would do something, and they didn't. So there are the grounds for judicial review against the PSR. One strategy to get the PSR to change their policies by bringing an action against them in court and the court ordering them to change it based on one of these or several of these 4 grounds. But in reality, judicial review is not straightforward. It is, again, a long process, expensive. You have to go to court, retain counsel, barristers, go to trial. It's not a quick win, as the slide says there. So bringing judicial review against the PSR or kind of any authority or the government isn't, it's not a quick win. In relation to the PSR, it's only happened once before, and the High Court found for the PSR. So that was in the case of Note Machine. And then other examples of judicial review against the Financial Conduct Authority or the FSA Financial Services Authority previous name, because we don't have any other examples against the PSR, so we'll just look at the ones against the FCA, also indicate that the court usually shows judicial deference towards the regulator. So judicial deference, so this means finding for the regulator, permitting that the regulator has followed the correct process. So they've discharged procedural fairness. Excuse me. So some examples just to demonstrate. In 2024, Client Earth brought judicial review against the FCA, asserting the FCA had not followed proper procedure when approving an IPO prospectus for a large oil company. The court ruled that the FCA did not have to consider climate risk when assessing a prospectus. So that was a claim for judicial review against the FCA that failed. The Court of Appeal also upheld the FCA's decision to assist the US Commodities Future Trading Commission with an ongoing investigation involving the applicant, which was Sudden. And then final example, excuse me, APPG has been given permission to bring judicial review against the FCA in relation to the RHP mis-selling scandal, alleging substantive due process, procedural fairness deficiencies. And this would appear to be going to trial sometime this year. So not a plethora of successful judicial review claims previously brought against the UK financial regulators. So it's, not a quick win. Just to give some context, it's expensive and lengthy and difficult and not assured success. So let's talk about scope of the PSR's reimbursement requirement, because there's still some outstanding questions in relation to scope. We originally thought, that this was simple and that there had to be a payer and a payee and a fraud. It's become slightly more complicated than that. So casting our minds back to simpler times in 2023, when we had policy statement 23-3, and the PSR published their policy statement, which is kind of like the policy that they're taking following the consultation process. So at this point in time, they had the reimbursement requirement. They knew they were going to have a reimbursement requirement. We didn't know it was going to be £415,000, but we knew that we would have to reimburse something, and this was going to be mandatory. We knew that it was going to be operationalized through the faster payment system. So it was going to be for payments across the faster payment system. And then in several paragraphs in policy statement 23-3, this is a paragraph from the policy statement, the PSR said that the new reimbursement would not apply to payments that take place across other payment systems. For example, if a customer sends funds to their account at a crypto exchange and then pays a fraudster via a cryptocurrency. So it's meant to be only payments that take place across faster payments. So whether it's over a crypto exchange, a crypto system, or SWIFT, or MasterCard, it's only meant to be faster payments. That's the point. It's payments over faster payments. New reimbursement requirement does not apply to international payments. So it's meant to be UK only payments, domestic payments in the UK. It's not to apply to payments made for unlawful purposes. So for example, payments for illegality, contracts for illegality are void. Similar situation here. You can't agree with someone, you can't pay them to commit a crime, for example. That would be void for illegality. So same here. And then civil disputes are also meant to not be reimbursable. So such as where the customer has paid a legitimate supplier for goods or services but has not received them, they are defective in some way, or the customer is otherwise dissatisfied with the supplier. So if you've ordered, the reimbursement requirement is not meant to apply to situations where you've ordered something online, it's arrived and it's not to your satisfaction. That would be a civil dispute whereby you're meant to exercise your consumer rights. That's not meant to be within scope of the reimbursement requirement. So from the outset, we had these 4 core carve-outs where the reimbursement requirement wasn't meant to apply. 4. This is from the outset. We were on board with the PSR this whole way that these 4 carve-outs did not apply. Can I pause? That's fine, we'll keep going. Actually, can I pause? Can I pause? No, I can't pause. We'll keep going. Okay. And in the same policy statement, 2023-3, the PSR made some statements about multi-step fraud cases. So they said, some APP fraud cases involve more than one payment. For example, the fraudster may socially engineer a victim to transfer money from their bank account to an account they hold at a different PSP. The fraudster then manipulates the victim to transfer money from that account to one outside the victim's control. These fraud cases can be referred to as multi-hop, multi-step, or multi-generational. So I transfer, so if, a customer is socially engineered, a victim, they transfer money from their bank account to another bank account, to another bank account, and then to the fraudster. So this would be multi-generational. It would still be reimbursable. But noting that here, the PSR is talking about payment accounts held by the victim or by the fraudster. There's no sense of accounts being held by someone else, unless it's like a money mule, whereby the victim would transfer funds to a money mule who is acting on behalf of the fraudster, and then the money mule would then pay the funds to the fraudster. But here, look, there's no sense of the relevant account or the payment account being held by someone else in this multi-step fraud case. When we refer to multi-step fraud cases, we are not referring to fraud across different payment systems, such as where a victim sends a crypto transaction to a fraudster. Figure 4 sets out potential examples of multi-step APP fraud cases. There are many more types of blah, blah, blah. Okay, so what is Figure 4? Okay, this is Figure 4. So we have single-step fraud. So there's a victim and a fraudster, and the victim sends a payment to the fraudster over faster payments. That's fine. The orange arrow means the payment over faster payments. So you send payments directly to a fraudster. Fine, that's very easy to understand. Use of a mule account, as we just discussed, that second line there. The victim sends the payment over faster payments to a money mule, and then the money mule sends out a payment to the fraudster using something else. Could be crypto, could be Swift, could be anything. Friends and family. So then the victim sends a payment to their friend. Individual sends a faster payment to a trusted family member account, which is then sent to a money mule. So just because, so you go victim sends a payment to a friend, the friend sends the payment to a money mule, and then the money mule sends the payment out to the fraudster. The orange arrow is the functional transaction that brings this in scope of the reimbursement requirements. Again, still on board, this is still kind of making sense, right? So there's still a payment over faster payment from the victim's friend to the money mule. It's not The reimbursement requirement isn't vitiated because the victim sent the money initially to their friend or by the involvement of the money mule. This is fine. We're still on board. Why would that vitiate the victim's right to reimbursement? It shouldn't. That's fine. We're still on board with this. The orange arrow is the functional transaction that brings it within scope. And then this line at the bottom is there's no in-scope payments because the individual funds their crypto account and then pays the fraudster in crypto. So they're going, no, this isn't over faster payments. This is a crypto transaction, not in scope. But what you'll notice is for these single-step fraud, use of mule account, and friends of family examples, look at the banks, the little buildings indicating the banks. All of these are accounts. All of these bank accounts indicated by the bank icon are held by a victim or a victim's friend or a money mule or a fraudster. There's someone involved in the fraud. There's no sense in any of these examples that any of these accounts are held by anyone other than individuals either associated with the consumer victim or with the fraudster. There's no sense here that there's some kind of internal payment by the PSP between their, their pursuant to their treasury function or between operational accounts or safeguarding accounts. There's no sense in any of this that that's the case. All of these accounts are held by victims or their friends or family or money mules or the fraudster. They're all individuals who are either being tricked or are the fraudster themselves. And then in the same policy statement, there was this wild annex that related to PSPs. And this got our spidey senses going, I guess, because we're on board with this. This makes sense. This is okay. The most wild one there is transferring funds to the friend, and then the friend transferring the funds to the money mule, and that orange arrow being the functional transaction that brings the fraud within scope. We're on board with this. We can get on board with this. It's okay. Why, why should a victim lose out just because there was this kind of intermediary transaction whereby they transferred the funds to their friend and then presumably convince the friend to then transfer the funds to the money mule? We're on board with all of these, and these are rational and make sense. Then we get to this wild annex in relation to PSPs. And I know this is old and we've all, already seen this already, but just to lay the foundation for the scope questions that we're going to address that have come up recently. As I just said, this got our spidey senses going. So model A, PSP, where they just initiate the transaction and don't come into the flow of funds, out of scope. Fine, agree with that. Model B has this, I'll try and stop saying wild, but I consider wild. So the PSP operates as the receiving PSP. So the PSP initiates the transaction. They then collect the funds into IntPay, whatever the green bank icon there is called, IntPay, I don't know. And the PSR here is saying the PSP is both the PSP and the receiving PSP. And then the PSP settles funds to the fraudster's bank account. So the functional transaction that brings this model within scope of the reimbursement requirement is the transaction initiated from the payer to the PSP's account, the PSP's operational account. Not the transaction between the payer and the fraudster payee. I mean, here it doesn't even really matter that the PSP is actually initiating the payment. The issue is that the PSP is actually acquiring credit transfers more so. So they're bringing merchant acquiring within scope of the reimbursement requirement. So this annex, this bizarre appendix or annex about PISPs, got our spidey senses up to note that there's something odd going on here with scope. And then this is text from the specific direction with the when we've gone through all the policy statements, we've gone through all the consultation policy statements, we're right at the end of the road, and the PSR has published specific direction 20, which is the specific direction that has the reimbursement requirement in it. And as you can imagine, the specific direction has a bunch of definitions in it. And one of those core definitions is faster payment system, FPS, APP scan payment. So it has to be this thing to be reimbursable. So an FPS APP scan payment for the purposes of this direction means an APP authorized by a victim as part of an APP scam that has the following features. Okay, so it has to have these 5 things. Executed through faster payments. Check, we need that. Authorized by a PSP's consumer. Yeah, it has to be authorized because it's an APP fraud. It's not an unauthorized transaction. That's already accounted for in the law. Executed by that PSP in the UK. The payment is then received in a relevant account in the UK that is not controlled by the consumer. 5, the payment is not to the recipient the consumer intended or is not for the purpose the consumer intended. So there's some kind of fraudulent intent there. So that's what an APP scam payment is. So that sounds really normal, doesn't it? That sounds like it accords with what we've discussed. It's not across another payment system. It said faster payments. There wasn't an international payment. It said received to a relevant account in the UK. It's not made for an unlawful purpose. And it's not a civil dispute because 0.5, it's not for what the consumer intended.